All right, Katir, thank you very much. We're at 5 o'clock. It's now up to Indiana's highest court to settle a fight between the governor and state lawmakers. The issue? Can lawmakers call themselves into special session? News 8's Garrett Berquist explains why this answer may turn on a few key phrases.
This case began almost exactly a year ago. That's when lawmakers overrode the governor on a bill to let them call themselves into emergency session. The question right now is not only whether that authority exists somewhere in the Constitution, but also whether the governor even has the authority to bring a lawsuit. It's the latest round in a two-year fight over emergency powers.
Your Honors, there is no disagreement among the parties or the trial court that from 1816 through 1851 until 1970, only Indiana governors had the authority to call special sessions of the legislature. Nothing about that special session authority changed in 1970.
And they said, we don't care if it's a special session, we don't need to have that. We need to have authority over sessions. I'm not sure what could be clearer than control over length and frequency of sessions. That is crystal clear. That is straightforward.
The legislature passed the law in response to Governor Eric Holcomb's 2020 COVID orders. They've never tried to actually call a session under the law, but say they want the option during a future emergency. The issue is two sentences in the Constitution. The governor may at any time call for a special session. The length and frequency of the sessions of the General Assembly shall be fixed by law. The governor's lawyers say if the authors of that language wanted lawmakers to be able to call their own sessions, they would have said so.
The language has to be self-executed. And if you look at all the 30-plus states that have these provisions, that's how they do it. And they knew how to do it in 1967. They proposed that language and didn't follow it.
The Attorney General's office, arguing on behalf of the legislature, says the governor can't even bring a lawsuit of this type in his official capacity. As for the argument itself, they say by that logic, lawmakers would need the governor's permission for anything other than their regular session.
Now, the technical session statute has been around since 1995. The legislature saw a need then, and it has been using it off and on for, at various times, not every year. But no one has been concerned that somehow this is not a fixed by law session.
We don't have a specific timetable for a decision. Chief Justice Loretta Rush says the court will decide in due course. At the State House, Garrett Berquist, WISH TV, WISHTV.com, and follow us on Facebook.